Okay, good afternoon, everybody. Before I begin today's class, I just wanted to very quickly mention a problem that many of you have probably encountered by now, and that is that the readings that are supposed to be up on in the course reserves on the Quarkus site are not yet there. I was informed last week that they would all be up there in time, and I neglected to check it first thing this morning, and didn't check it until I got into my office. Otherwise, I would have put them up in the files section. But I will put all the readings that you're responsible for up to this point in the files section as soon as I get home this evening. So they will be available to you by tomorrow. And I apologize for that misunderstanding and for your falling behind the readings. But we'll make the best of that and try to get caught up. So if you haven't found the readings, please don't get frustrated. They will be available to you as soon as I get back back home and get onto my computer. Before I begin today's lecture, let me briefly see whether there's any quick questions about anything that we've covered thus far, or anything else related to the class, before I go into new material. Okay. If not, then I'd like to pick up last class where I began to discuss the U.S. Constitution and its implication for the making of foreign policy. And in that regard, I want to highlight essentially that the purpose of the U.S. Constitution was above all else to limit government power, For those of you particularly interested in that aspect of the American Constitution, one of the sources that is still among the most enlightening about the intent of the framers is a series of essays called the Federalist Papers that you can Google and are readily available. And they are essentially essays that were written by three of the main proponents of the U.S. Constitution, John Jay, Alexander Hamilton, and James Madison, in order to convince people to vote in favor of the Constitution, because of course the Constitution was approved by conventions held in each of the separate states, and a yes vote in at least 2/3 of those was required. And consequently, the proponents of the Constitution went to work trying to convince the American public that it was in their best interest to subject themselves to this Constitution and the government that it created. One of the most interesting articles in that collection is, I believe it was Federalist number 54, which is an essay written by James Madison, in which he essentially argues that the purpose of government, as he sees it, is above all else to protect the rights of its citizens, And of course that was implicit in the American Declaration of Independence, which you might recall starts with the preamble in which it is stated that we hold these truths to be self-evident, that all men are created equal, that they are endowed by their Creator with certain inalienable rights, and that it is the duty of governments to protect those rights, and that any government, and I'm paraphrasing here, any government that violates those basic rights therefore loses its legitimacy, and that it is the right and indeed the duty of its citizens to alter or abolish it. In other words, to overthrow it. Basically, that was an argument for the right to revolution when a government violates the rights of its citizens. And in that Federalist number 54, he argues that the biggest threat to liberty, to the rights of individuals, invariably is what he called factions. And he defines factions as any group motivated by a common interest or passion. Any group motivated by a common interest or passion. And went on to argue that there are, of course, many factions, and the organization of groups that are motivated by a common interest or passion is of course a hallmark of any legitimate democracy that allows for the freedom of organization, freedom of speech, and things along those lines. And that under normal circumstances, factions are not particularly problematic, especially when they represent a fairly small group within a society. In that kind of an instance, their ability to threaten the rights of others within that community is inherently going to be checked by more powerful majorities that will keep them under control. Factions become problems for the rights of individuals when they represent a majority of the population. When they represent a majority of the population. In that case, they can institute policies that threaten the rights of minorities. And it is the purpose of government, or it is the purpose of a constitution, I should say, to design a government that makes it very difficult for such majoritarian factions to violate the rights of other citizens. And essentially that is the purpose of the Constitution. Now it should also be noted that in the very first paragraphs of that essay, in defining factions, he also suggests that the most common cause of factions, and the most dangerous in this regard, is invariably the uneven division of wealth within a society, which creates a class of individuals that are wealthy, but are a small minority, and a rather large majority likely to be envious of the privileges and wealth of that minority. And in that regard, the great historian Charles Beard essentially argued in his book, The Economic Interpretation of the Constitution, that the main purpose of the US Constitution was indeed to protect the property minority from the propertyless majority. And that, in essence, the Constitution was set up in order to prevent the ability of that powerful majority to organize itself through this system of checks and balances. Through dividing power among a number of different institutions that are meant to keep each other in check and limit the powers of government. Another way of looking at this is that the US Constitution embodies a set of philosophies, those of the liberal political philosophers that dominated the period, John Locke in particular, Montesquieu, who first came up with the idea of a separation of powers, and perhaps above all else, Adam Smith and his book, The Wealth of Nations, which was published in the year that the United States gained its independence. And the basic philosophy or the basic common denominator that these three political thinkers had is well summarized by the basic adage that government governs best which governs least. That government governs best which governs least. In other words, which leaves as much freedom to the individual as possible. And therefore, the US Constitution was created in order to create a government that is likely to govern as little as possible. And how do you make sure that a government governs as little as possible?
You make it extremely inefficient with all the different checks and
Precisely. You make the process of passing legislation, of forming policy, as inefficient as it could possibly be. As inefficient as it could possibly be. And indeed, and I don't want to get too much into the discussions of domestic politics in the United States, since we're more interested in the foreign policy aspect of this, but if you try to imagine a system of government that is less efficient in producing legislation than the United States form of government, you would be hard-pressed to do so. And indeed, the US Constitution in this regard is a reaction to the perceived efficiency of parliamentary systems of government. Parliamentary systems of government which are much more efficient simply by virtue of the fact that, as we know in Canada and in Britain and elsewhere, if you have a majority control over the House of Commons, you can pretty much push through any piece of legislation that you like and can do so very effectively. There are no serious blocks in the way of majorities in a parliamentary system. In the United States, by contrast, the legislative process is indeed very inefficient. And part of the reason for that is that political parties do not function the way that they do in parliamentary system. The purpose of political representation in the United States is not to represent a political party, but rather to represent the interests of your constituents. And if those interests, if you're a member of the Democratic Party and the interests of your constituents contradict the party platform, every member of the House of Representatives and every member of the Senate knows precisely where their bread is buttered. And it's not buttered with the leadership of the Democratic Party or the Republican Party. It's buttered by their constituents. They decide whether they're going to be reelected or not the leadership of the party. And in that sense, if there's a contradiction between the interests of your constituents and the program of your party, you vote with your constituents, not with your party. That's becoming somewhat less apparent in the current environment of political polarization in the United States, especially under Trump, but has been the common denominator of American politics throughout most of its history. That partisan votes, that in which every Republican votes one way and every Democrat votes a different way, are the extreme exception to the rule, rather than the rule itself, as is usually the case in parliamentary systems. So how is legislation made? Well, it's a very slow and ponderous process. Any member of Congress can introduce a piece of legislation if they like it. And when they do so, usually there's only a point to it if they can get somebody in the other house to do so simultaneously. And so therefore most bills have two names attached to them, one of a senator, one of a member of the House of Representatives, that introduce the bills. When the bills are introduced, the first thing that happens is that they are assigned to a committee to go over the bill. And in that sense, both houses of Congress are divided into various committees: House Agricultural Committee, a Senate Agricultural Committee, a House Armed Services Committee, a Senate Armed Services Committee, a Foreign Relations Committee in both houses, and so on and so forth. And the leadership in both houses will look at the bills and say, well, this is, for example, a dairy price support bill or something along those lines, therefore should go into the House Agricultural Committee. And once it's in the House Agricultural Committee, they'll look at it and they say, well, this is a dairy bill, and therefore should go to the subcommittee on dairy products. And guess who sits on the subcommittee for dairy products? In the House of Representatives, or for that matter, in the Senate. Who would sit in those committees? Who would want to be in those committees? Well, representatives that have constituents that are heavily involved in the dairy industry. And if it's a bill for price support for dairy, then chances are they're all going to be on the same page, and they're going to go, yeah, right on, let's pass that on. And then the bill goes from there back to the committee, or the Agricultural Committee. And the Agricultural Committee will consist of people that are from a whole bunch of different states, but one thing they'll all have in common is that they're all from states that have a fairly significant agrarian economy. In other words, they sort of share the same interests as the dairy farmers, but the second they get that bill with the dairy support suggested, they'll say, well, why should we vote for this? What's in it for me? Why should I vote for it? And usually the way that it works is that the bill will be adapted, in essence, to make it more attractive to other members of the House Agricultural Committee. And usually what that means is, well, if the dairy folks, the farmers are going to get price support, then why not the wheat farmers too? And why not the soy farmers too? And why not the cattle ranchers and so on and so forth? So that suddenly this bill expands into something much larger. And then when it gets into the floor of the House, again, everyone in the floor of the House is going to be saying, well, why should I vote for this? What's in it for me? And consequently, more things get tacked onto the bill. And consequently, what emerges out of these processes is invariably something that's described as an omnibus bill that consists of a whole slew of things that various people want, in essence, to create a majority to get the thing passed. Now, if it gets passed by both houses of Congress, does it become law? No, it does not. And the reason for that is because by the time it's gone through this process in both houses of Congress, the bill that's in the Senate will look substantially different from the bill that's in the House of Representatives. So the first thing that has to happen is that they have to figure out some compromise between these two different bills so that they can make them identical. And then present them again to the House and the Senate in identical form to get passed. If they can't come up with a compromise that meets meets that qualification, the bill is dead. If it ever doesn't make it through one of the committees or the subcommittees, the bill is dead. The implication of that is that for every 1,000 bills that is submitted to Congress, 1 or 2 perhaps passes. Now, if they aren't successful in being able to unify the bill into a single bill that is identical in both houses, and both houses repass it, is it the law then? The answer is no. It becomes the law if the president signs it into law. So the final check in this regard is the president. The president has, in this context, 3 choices. He can ignore it altogether, in which case it becomes the law automatically after 10 days without his signature. He simply doesn't endorse it. He can sign it, in which case it becomes the law immediately. Or there's one third option, and that is that a lot of bills get passed by Congress just at the end of the congressional session. Basically because there's that 10-day requirement, if there's not 10 days left in the session, the president can exercise what's called a pocket veto. In other words, he doesn't sign it, but since the 10 days can't elapse, it simply is dead on arrival. In that case, the whole process has to start in the next legislative session again. The basic point that I'm trying to make is that this is an enormously inefficient process. One of the things that we should think about in this regard is back when we were talking about politics in our very first session and about the contrast between domestic politics and international politics. One of the things that we argued is that there is a requirement, especially in foreign policy, for what? What did Carl Schmitt argue was necessary in dealing with foreign policy? Anyone recall? Efficiency. In essence, he argued that foreign policy trumps domestic policy, in large part because before any society can decide what policies to adopt, what kinds of laws to pass, what kind of things to subsidize or not to subsidize and to outlaw, they first have to be safe from their enemies abroad, from the threat of chaos always posed by external forces. And that means that on the one hand, you have a constitution that creates enormous inefficiencies. And for those of you that watch watch American news, gasp at how little Congress is capable of doing, of how much it dithers and does nothing when there are glaring problems that the United States has to deal with. And whenever something is suggested, it gets knocked down and so on. This is not an aberration in American politics. This is precisely how the Constitution was intended to function. It was intended to be as inefficient as possible. But security matters and foreign policy matters require efficiency. And that means that there is a fundamental problem for the American Constitution. It creates a system of checks and balances that makes government enormously inefficient, but then has to deal with foreign policy somehow. And the Constitution, as I suggested last week, seems to suggest that this system of checks and balances should also apply to foreign policy. That foreign policy likewise is not under the control simply of one individual, the president, but the powers relating to foreign policy are likewise shared by these various institutions. In that regard, the president may be the commander-in-chief of the armed forces. He may be the sender and receiver of ambassadors and have the power to recognize foreign countries. And he may be in power to appoint various officials within his government. But all of that has to be done with the advice and consent of the Senate and Congress in general. And furthermore, he can only do what the House of Representatives, which passes all revenue bills, provides them funding for doing. In that regard, it seems that the system of checks and balances is indeed intended to also apply to foreign policy. And that would indeed imply that the United States, when compared to other powers in the international system, such as China, such as Russia, especially more authoritarian governments, essentially deals with foreign policy, apparently with one arm tied behind its back. In other words, with a serious disadvantage in being able to formulate policy effectively and quickly in order to respond to foreign threats and foreign challenges. How is that possible? And how is it possible that a country like the United States has existed under this system, constitutional system, for close to 250 years, and during that period has risen from a relatively backward and well, I hesitate to say primitive, but relatively undeveloped state, largely agrarian, to becoming one of the financial and industrial powerhouses by the end of the 19th century, a superpower in the middle of the 20th century, and ultimately the dominant state in the international system today. It's a question that's not all that easy to answer. One answer to it is that the United States essentially was able to succeed in the context of these institutions, in large part because it is exceptional. Now, the word exceptional, as applied to the United States, you will hear on a number of occasions. In this context, I mean it is exceptional in terms of its basic circumstances. It is exceptional in its circumstances in that, unlike most other countries in the international system, throughout most of its history, beginning at the time of the establishment of its own sovereignty, it has not faced any external threats. It has not faced external threats. In other words, none of its neighbors were capable of threatening American sovereignty. Insofar as American sovereignty could be threatened, it was threatened by powers an ocean away. And those powers that were an ocean away were focused on each other as primary threats, and consequently simply didn't have the luxury to threaten the United States. In other words, it's a system that works as a fair weather system. As long as you have no threats, as long as foreign policy is of no big concern to you as a country, you can deal with this kind of a system. And it will function perfectly. Well, maybe not perfectly. The inefficiencies domestically might still bug you and might still have decisive disadvantages, as indeed they do in the United States, despite the glaring need for universal health care, still hasn't adopted that. The United States spends more on health care than any other country on the planet, but in the process doesn't manage to cover most of its, or quite a sizable portion of its own citizens with health care. That's a matter we won't be too concerned about. In that sense, the inefficiencies certainly do have impacts domestically as well. But how is it that the United States was able to overcome these things when it was at various points challenged? One of the first instances in this regard was the Civil War. The Civil War was a major threat to the stability of the United States and the security of the United States. And for those of you that have studied international relations, most of you are probably aware that civil wars, including the one in the United States, are never entirely matters internal to the country in which they take place. In other words, that there are always outside players involved in civil wars, and indeed in the United States Civil War there were as well. As such, the British viewed the beginnings of the Civil War as an opportunity to regain some dominance over the United States, and consequently backed the South in its attempt to break away from the United States. France became involved in the American Civil War to a large extent by backing the northern states. Suffice it to say, however, that this crisis, for the first time, made evident something about the institutions of American government and how they would evolve as the United States became a more powerful player and as the protection that it enjoyed, that made it exceptional throughout the 19th century, started to change as a result of transportation, technologies, and so on and so forth. Famously, President Lincoln declared in the Civil War that the U.S. Constitution is not a suicide pact. The U.S. Constitution is not a suicide pact. And what did he mean by that? What he meant by that is, well, somewhat complicated, but not as complicated as you might think. In essence, the Civil War was the result, as most of you know, of the southern states deciding to break away from the American Union. President Lincoln stated, you can't do that. It's not allowed under the Constitution. And in that regard, he was on somewhat weak ground, because one of the unique things about the Constitution is that it was deliberately ambiguous to plaster over various kinds of issues that might cause trouble in terms of getting the Constitution passed to begin with. And one of those issues is where sovereignty resided. Did sovereignty reside in the states that then authorized the federal government to look after its common affairs? Or did sovereignty reside in the United States as an entire entity, in which case the states no longer had the right to secede from the Union, whether they liked it or not? The beginning of the U.S. Constitution says the authority of the Constitution comes from we the people. We the people, in order to form a more perfect union, blah, 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 blah. Suggesting that it was we the people of the United States that created the American government, and that only we the people could take that authority back. The conclusion of the Constitution, by contrast, states that done in convention by the separate states, that held separate conventions to authorize the Constitution, suggesting that the authority for the Constitution came from the states, and that therefore the states had the right to take it back. In the lead up to the Civil War, essentially the southern states declared that they considered themselves sovereign and had the right to withdraw from the Union and to form their own confederacy, their own system of government that, above all else, allowed for slavery. And Lincoln said, no, you can't do that. That's against the Constitution. And then sent in the military to enforce it. The implication of that is that those that were fighting on the rebel side, on the southern side, were rebels, and therefore were criminals, were not soldiers, and therefore were not entitled to treatment as prisoners of war, but rather would be treated as criminals. Now, what's the problem with that? Anyone know the American Constitution well enough to know why that would be problematic? What happens when somebody's accused of a crime in the American system of government? What does the Bill of Rights say about that? Well, the Bill of Rights says, no one shall be deprived of life, liberty, and property without the due process of law. And the due process of law means that they have to be presented with charges, that they have to have the right to contest those charges in front of a judge and a jury, and so on. Now, if you declare an army of several 100,000 to all be criminals, and you have to provide them with access to courts and a jury every time you manage to capture one of them on the field, does that make any sense? Is that even possible? Well, the alternative was to declare that they're soldiers, in which case you don't have to try them, you can arrest them as prisoners of war, keep them until the war is over, and then release them. But that would legitimate the claim that the South was a sovereign state, and Lincoln was certainly not going to do that. And consequently, he simply stated habeas corpus. In other words, habeas corpus is a Latin legal term for we have the body. In other words, when the state arrests somebody, they have to acknowledge that they have been arrested and then have to provide them with access to the courts. That right was simply suspended, despite the fact that it was a core component of the Constitution. In that regard, the Constitution was not a suicide pact. And what that means is essentially that the Constitution has been in various ways reinterpreted over time in order to facilitate a functioning state and to meet the basic challenges that are required for a state in the international system. I believe I went through the basic powers of the President and Congress. The President, as I mentioned just now, is Commander-in-Chief of the Armed Forces, first and foremost. Sends and receives ambassadors, negotiates treaties, and things along those lines. And beyond that, his role is simply to see that the laws passed by Congress are faithfully executed. In that regard, the framers of the American Constitution considered the presidency a relatively unimportant office. a relatively unimportant office because he was essentially a head bureaucrat who took his direction from Congress. Congress passed the laws, and he simply passively implemented the laws passed by Congress. Congress allotted money to be spent on various things, and the president simply took those directions from Congress and implemented them. That was his function, except, of course, in foreign policy. But foreign policy didn't matter much throughout most of American history for a whole suite of different reasons that we'll explore in a bit more detail as we move forward. I should, in that context, also point, or let me finish off on that thought. Congress, by contrast, has the powers in regard to foreign policy, that it declares war, not the president, and that it raises and supplies an army and navy, meaning that the purse strings are in the hands of Congress. And the ability to declare war, to authorize military action, likewise is in the hands of Congress. The third branch is the judiciary. And the role of the judiciary is to protect the Constitution, in essence, to keep either the president or the Congress from doing things that are contrary to the Constitution. Now, as many of you that have taken American government courses probably are aware, the U.S. Supreme Court consists of 9 judges, all of which are appointed by the president with the advice and consent of the Senate for life. For life. Why would you appoint judges for life? To insulate them from public pressure. In other words, to put them in a position where they can make judgments on the basis of their philosophical beliefs and not be influenced by the possibility that they may not be reelected or that they may be removed from office. In that sense, the Supreme Court was supposed to be another check on democracy, another check on majority factions, in case the president or Congress fail in their ability to protect the rights of minorities. But one of the things that's unique about the U.S. Constitution, as I mentioned before, is its vagueness, its ambiguity. And the Supreme Court in that regard was not unaffected by that ambiguity. How would you feel if you were presented with a possible system of democratic government in which there were institutions that were elected, like the president and the 2 houses of Congress, and then at the bottom of that it said, well, and then there's these 9 judges that are going to be appointed for life, and that can overrule acts of Congress or the president if they don't like them. Do you think that was a good idea? Would you vote for that kind of a system? Where 9 unelected officials can overrule the actions of all the officials that are elected by the general public? Well, the framers of the American Constitution clearly didn't think that that was something that they could sell to the public. And therefore, there is no mention of the right of the Supreme Court to overrule acts of Congress or the president in the Constitution. Does the Supreme Court have that right? Absolutely it does. Where does that right come from? It was a right that was usurped by the court itself, not one that was stated in the Constitution. And the case in this regard, for those of you interested in, is the case of Marbury versus Madison. The case of Marbury versus Madison involved the first attempts by a government in the United States to stack the courts with like-minded judges. In essence, what happened in the elections, prior to the elections of 1800, is that parties very quickly emerged. The parties were initially the Federalist Party that strongly supported a strong central government and the U.S. Constitution, and the Anti-Federalists, led by Thomas Jefferson, that resisted the idea of a strong government and insisted on greater states' rights. And in 1800, Thomas Jefferson defeated the Federalist candidate to become president, and John Adams, the Federalist president that still held office. One of the peculiarities about American politics is that the elections take place in November, but the new president doesn't come into office for quite a while until later. Currently, the new president takes office January 21st, I believe it is. But back then it was April, mid-April, so essentially a 6-month period from the time that the sitting government is defeated until the next government takes power. Basically, the Federalists had lost not only the presidency, but also the majority in the Senate, in the House of Representatives. They viewed Thomas Jefferson essentially the way that Republicans now view Mr. Sanders or something along those lines. It's a irresponsible radical that will ruin everything. And consequently, they wanted to throw as many hurdles in the way of him being able to do that as possible. And the best way they figured out to do that is to create a whole slew of federal judgeships and to stack all of the judges with solid Federalists. They did so. Adams created all these judgeships, appointed reliable Federalists to them, handed the judgeships to the Senate for approval. The Senate approved all of them. Then he handed them over. But by some odd mistake, the judgeship for Marbury was still sitting on the desk of the Secretary of State when the new government came in. The Secretary of State was James Madison, and he asked Thomas Jefferson, "What should I do with this?" Now, this was a judgeship that had already been approved by the president, had already been approved by the Senate. In that sense, it was a done deal. And Jefferson just said, "Forget it, don't hand it over." I refuse to cooperate with this because this was clearly an attempt to stack the courts, and as such is illegitimate. And therefore, Marbury sued and basically asked the court to hand down what was known as a writ of mandamus. A writ of mandamus is simply an order to a public official to carry out his duties, in this case to hand over the judgeship. The power to issue writs of mandamus was given to the court in the Judiciary Act of 1789 that spelled out most precisely what the court was able to do, and presented the court with a quandary. If it handed over the judgeship or if it issued an order to hand over the judgeship, Thomas Jefferson already said, "I'm going to ignore it. I don't care what the Supreme Court says. And if they want to expose themselves as powerless to enforce their decisions, as indeed they are, go ahead and let them. That'll set a very dangerous precedent for their future power." If they did what they all had the inclination to do, was to force that judgeship to be handed over, they would have exposed themselves as powerless. And they certainly didn't want to side with Thomas Jefferson and say, no, the judgeship all of the judgeships were illegitimate, and therefore to open that can of worms. Consequently, Chief Justice John Marshall had a brilliant idea. He simply declared the Judiciary Act of 1789 that gave the court the power to issue writs of mandamus unconstitutional. And by doing so, nothing had to be enforced. He didn't have to hand over the powers of the judgeship to the judge, but he asserted a power of the court that was going to be the precedent from that point on. In other words, that the court had the right to overturn acts of Congress and the president. And he also recognized that while this got him out of trouble and enshrined a component of Federalist preferences, in other words, a powerful court able to constrain the government in this regard, that this was a very dangerous matter. In other words, that people would be pissed off by this. And if they were pissed off enough, they could pass an amendment to the Constitution that makes it explicit that these 9 judges don't have the power to overrule the elected officials. And therefore, the Supreme Court has always been very careful in terms of how it uses that power. It did not use that power again for 50 years. Anyone know what the next time was that the Supreme Court overruled an act of Congress? Very famous case. It was the Dred Scott case. The Dred Scott case involved the period prior to the Civil War when the Congress had briefly tried to create a compromise between the North and the South by declaring all states that were below the Mason-Dixon line, the northern border of Tennessee, I believe it is, slave states, and all the states above that line to be free states. And what occurred in, I believe it was 1854, is that the owner of a slave, Dred Scott, took Dred Scott on a trip to the north, and the second they crossed the Mason-Dixon line, Dred Scott said, "Now I'm a free man. I'm not coming back to the South with you." And his owner said, "The heck you are. You're my property." And it went to the courts, and the courts ultimately decided in favor of the slave owner. They essentially argued that what is property in one state has to be recognized as property in all other states. And essentially, by doing so, kind of made compromise over the issue of slavery impossible and led the way to the Civil War. Suffice it to say that power remains somewhat controversial, although by now is well enshrined in the precedent of the Supreme Court over many centuries. That has put the Supreme Court in a position of deciding, in essence, the balance of power between the other two branches. And the reason I bring this up is because we are, of course, very much interested in the actual division of powers over foreign policy. And in that regard, what I wanted to draw your attention to today is how the Supreme Court has defined the powers of the president, the foreign policy powers of the president. And toward that end, I put on your reading list two court cases that deal specifically with this issue. The first one is the case of the Curtiss-Wright Export Company versus the U.S. And that case took place in 1936. And involved a conflict over a war that was going on at the time in South America. A conflict between Paraguay and Bolivia over the Chaco region in South America, a border conflict, that turned into a war. And the United States, having declared itself a kind of a regional hegemon with the Monroe Doctrine, felt that it reflected poorly on their ability as a moderator of affairs in the Western Hemisphere to allow this conflict to go on. And therefore, Congress authorized the president to do whatever he thought was necessary to bring this conflict to a halt. And President Roosevelt decided the best way to bring this conflict to a halt was to impose an arms embargo on both parties. And therefore, he outlawed the sale of armaments to both sides. But the Curtiss-Wright Export Company decided nonetheless to sell 14 machine guns to Bolivia. When Roosevelt got wind of this, he had those machine guns seized, whereupon the Curtiss-Wright Export Company sued the government. And their claim was fairly straightforward. Their claim was that the president did not have the authority to do so, did not have the authority to impose an arms embargo, that imposing an arms embargo required an act of Congress. And that Congress, by simply passing a bill saying, let the president do whatever he thinks is best to bring this conflict to an end, had illegally delegated legislative authority to the president. The Constitution clearly states all legislative powers of the American government are hereby vested in Congress, not in the presidency. The president only has passive powers over that in terms of vetoing or signing the laws into effect. I'll read you a portion of the opinion of the court in this regard because it's quite telling. Whether if the joint resolution had related solely to internal affairs, it would be open to challenge that it constitute an unlawful delegation of legislative power to the executive, we find it unnecessary to determine. The whole aim of the resolution is to affect a situation entirely external to the United States and falling within the category of foreign affairs. It will contribute to the elucidation of the question if we first consider the differences between the powers of the federal government in respect to foreign or external affairs and those in respect to domestic or internal affairs. That there are differences between them and that these differences are fundamental may not be doubted. The two classes of powers are different both in respect to their origin and their nature. The broad statement that the federal government can exercise no powers except those specifically enumerated in the Constitution, and such implied powers as are necessary and proper to carry into effect the enumerated powers, is categorically true in respect to our internal affairs. In that field, the primary purpose of the Constitution was to carve from the general mass of legislative powers then possessed by the states such portions as it was thought desirable to vest in the federal government, leaving those not included in the enumeration still in the hands of the states. And since the states severally never possessed international powers, such powers could not have been carved from the mass of state powers, but obviously were transmitted to the United States from some other source. During the colonial period, those powers were possessed exclusively and were entirely under the control of the Crown. By the Declaration of Independence, the representatives of the United States of America declared the United States, not the several colonies, to be free and independent states, and as such to have the full power to levy and conclude war, peace, and so on and so forth. It results that the investment of the federal government with the powers of external sovereignty did not depend upon the affirmative grants of the Constitution. The powers to declare and wage war, to conclude peace, to make treaties, to maintain diplomatic relations with other sovereignties, if they had never been mentioned in the Constitution, would have vested in the federal government as a necessary concomitant of nationality. Neither the Constitution nor the laws passed in pursuance to it have any force in foreign territory unless in respect to our own citizens. I won't read the rest of the opinion. I suggest that we do so once I post it on our website, because I think the logic behind it is quite interesting and worth exploring. But essentially, what is the attitude of the court expressed in that particular case is, in essence, in keeping with the perspective of Carl Schmitt. Carl Schmitt argued that governments or states have to be able to act internationally in a way that is as efficient as possible, and that any attempt to constrain their powers by tying them to a constitution or to the rule of law is essentially to commit suicide in the international system. Basically, the implication of the Curtis Wright Export Company versus the US case is that when it comes to foreign policy, the powers of the president were not created by the Constitution and are not limited by the Constitution. And that's a pretty drastic statement, and one that many to this day continue to be rather uncomfortable with. And in that regard, while the Curtis Wright export case is still precedent, it has never been overruled, there are a couple of other cases in the record of the Supreme Court that point in a slightly different direction. And in that regard, one of the other cases that I put in your reading list is the Youngstown Tube and Sheet Company versus Sawyer. This case took place in the 1950s, in the early 1950s, and essentially involved a labor conflict between the steel industry and the United Steel Workers, which were preparing to go on strike to get better pay and better benefits from their employers, who were not inclined to grant these better conditions and better compensation, and were driving the situation to a strike. President Truman, in that context, decided to step in and simply to nationalize the steel industry, to take over the steel industry and impose a labor contract favorable to workers on the steel industry. And his justification for doing so, if you think about it for a minute, what was happening in the early 1950s that would provide such a justification? The United States was in the middle of the Korean War. And essentially the argument made by Truman is that the Korean War, the fact that the United States was at war, meant that the United States required a steady and reliable source of steel, and that therefore a steel strike was a threat to national security. And as a threat to national security, justified the president doing whatever was necessary to prevent such a threat, including imposing a labor contract favorable to workers and not accepted by management on the steel industry. The Supreme Court looked at this, and again, I would ask you to read the case and the logic behind it, but basically rejected that claim. Arguing that in this case it seemed fairly evident that President Truman was perhaps more concerned about his re-election chances than about the stated problem with the steel industry. In other words, that he was using a foreign policy justification to achieve something that was primarily motivated by domestic political concerns. And as such, this was illegitimate. Had to be done by Congress if it was possible to do it at all. In other words, there are some constraints on the president with respect to using national security as a justification for initiating various kinds of policies. You might note, by the way, that this is a conflict that is far from over, and that this is a controversy that's far from over. Just a couple of years ago, Canada was at the receiving end of a bit of American foreign policy. Anyone who know what happened 2 years ago between the United States and Canada? Anyone remember that far back? One of the first things that Trump did with respect to Canada?
Tariffs on Canadian steel and wood?
Canadian steel and aluminum. Canadian steel and aluminum. And why did he impose those? What was his justification?
National security.
National security. And the Constitution in this regard is fairly straightforward. It is the power of Congress to regulate commerce between the states and with foreign countries, not the power of the president. And in this regard, President Trump basically did the same thing that Truman did, is that he used a foreign policy crisis to essentially usurp a power that should really rightfully be in the hands of Congress. It would have been possible for Canada to take this case to the Supreme Court. They never did, and it would have been rather difficult for them to do so as a state actor. It might have been possible for individual steel corporations in Canada to do so. To the best of my knowledge, they have not challenged it legally. In that regard, the tendency to use national security as a justification for expanding executive power is something that is well entrenched in American politics, and certainly did not come to an end with the Uncounted Sheep Tube Company versus Sawyer. The Supreme Court in this regard has established itself as the kind of arbiter of what is legitimate and what is not legitimate, including in the realm of foreign policy. And another case in this regard that is worth mentioning is the case of Boumediene versus Bush. The case of Boumediene versus Bush, as you might anticipate, involved the War on Terror. And in particular, the ability of the Bush administration to hold individuals in Guantanamo Bay and elsewhere without access to a judge and jury, without charging with any offense, and without giving them access to the International Committee of the Red Cross, which is required under international law with respect to prisoners of war. The Bush administration basically argued that these were not prisoners of war, that they were illegal combatants because they were not state actors, and therefore did not require the niceties of the Geneva Conventions. As Donald Rumsfeld so nicely put it, the Geneva Conventions have become quaint and outdated. Furthermore, and in large part because he understood the weakness of that argument of not considering the arrested people prisoners of war. The Bush administration made sure that they were not brought into the United States. And the main reason why they were sent to Guantanamo Bay is because Guantanamo Bay is outside of the United States. And since it's outside of the United States, the claim by the Bush administration was the Constitution simply doesn't apply. He can do whatever he wants in that context. And in the case of Boumediene versus Bush, well, the Supreme Court actually knocked that down on 3 different previous occasions, but on much narrower grounds. And basically left the door open for Congress to try to authorize the detention in Guantanamo Bay. In the third and final case, the Boumediene versus Bush case, essentially the Supreme Court stated that the claim that that Guantanamo Bay is not part of the United States territory is absurd. It's certainly not part of Cuban territory. If Cuba had exercised sovereignty over Guantanamo Bay military base certainly wouldn't be there. In other words, it is quite clear that insofar as there is a sovereign authority that exercises control over Guantanamo Bay, it is the United States. And if it's the United States, then the Constitution applies in that context. And technically, therefore, all of those individuals in Guantanamo Bay should have been given access to American courts, should have been transferred into the United States, but that obviously has never happened. And in that regard, it's still one of those glaring problems with the American system, that the policies of the United States aren't even really in keeping with the requirements of its own laws or its own Supreme Court decisions. And this decision came back down in 2008, in the last year of the Bush administration. And of course, Barack Obama promised to close Guantanamo Bay as one of his core promises when he was elected president. But as most of you know, there are still 150 prisoners sitting in Guantanamo Bay, most of them, almost all of whom have been cleared of any connection to terrorism by the intelligence agencies of the United States. But the United States continues to refuse to let them go. Why is anyone's guess? Probably one part of their thinking is that these folks might not have been terrorists when they were arrested. They might not have had anything against the United States when they were arrested, but now that they've been tortured and locked up for 15, 20 years, they certainly do have something against the United States, and therefore probably not such a great idea to let them go. I don't mean to be cynical about that, but there's plenty of room for cynicism when looking at the current environment in the United States. The upshot of this is that the Supreme Court, while imposing certain restrictions on the executive, certainly has left the door open for expanding executive power. And in that regard, executive power has expanded tremendously since the passage of the American Constitution in 1789. Something that was well understood by the first president of the United States, George Washington. George Washington, in his farewell address, which is still quoted extensively, counseled his successors to do whatever possible to avoid getting the United States into what he called foreign entanglements. In essence, most historians writing on American history argue that it was his speech and his counsel against foreign entanglements that resulted in a policy on the part of the United States of isolationism, of staying out of international politics for the first 150 years of its history. That's somewhat misleading. The United States may have stayed out of foreign entanglements, but it certainly was not isolationist. If by isolationist you mean a country that becomes self-sufficient, that has little contact with other societies around the world and so on. The United States, from the very beginning of its history, was a trading empire, and in that sense sought commercial connections with countries around the world. What George Washington instead was recommending, and what the United States has to a large extent attempted to preserve, is its ability to act unilaterally. Unilateralism. George Washington understood in this regard that the United States, being a very weak country at the time that he governed, if it formed foreign or entanglements, in other words, alliances, would invariably be forming alliances with stronger states, states like France, for example, against Britain. And in that context, would have to make certain commitments to its treaty partners, and those commitments would be likely to drag the United States into conflicts that those greater powers were likely to be involved in, and in Europe there were plenty of conflicts, but in which the United States had no real stake. And consequently, he argued it was best for the United States to stay out of these foreign entanglements and essentially look after its own self-interest, unilaterally. But he went a bit further than that. He argued that the reason why the United States should stay out of these foreign entanglements wasn't simply to assure that they could unilaterally defend their own self-interest, but also because foreign policy represented a fundamental threat to the American system of government. He argued essentially that insofar as the United States became more involved in foreign affairs, the balance of power in the system of separation of powers would invariably shift toward the president and weaken Congress, and thus undermine the system of separation of powers. And furthermore, he argued that the increasing involvement of the United States in foreign affairs would inherently strengthen the the federal government at the expense of the states. And although we have discussed it extensively, the system of separation of powers focuses for the most part on the federal government, but one crucial component of that is the separation of powers between state and federal governments. And clearly the federal government would become more dominant. And to a certain extent, that without doubt has happened. The federal government became unambiguously more powerful in the aftermath of the Civil War with the passage of the 14th Amendment that made it clear that the US Constitution applied to all of the states. It has gotten much more powerful in the 20th century, in large part as a result of institutional changes. There's always been somewhat of a pendulum effect within American politics between congressional dominance and presidential dominance, in which whenever crises arose, such as the War of 1812, the Civil War, the Spanish-American War, the pendulum of political power would swing in favor of the presidency. But the overall pattern was that once that crisis was resolved, the pendulum would swing back and Congress would reassert itself, reestablishing a kind of a balance. And that occurred in the Civil War, after the demobilization of forces after the Civil War. It occurred after the Spanish-American War with the demobilization of forces. And it occurred at the end of the First World War, when the military was again demobilized, and the United States returned to a very small military corps of officers for the purpose of rapid mobilization. That changed, however, or the balance changed rather drastically, domestically, as a result of the Great Depression and the New Deal legislation that created a huge bureaucracy within the executive branch to manage the welfare state, to manage Keynesianism, to manage Social Security and all the various measures that went with it. That expanded the bureaucracy within the executive branch drastically. In regard to foreign policy, the executive branch was expanded drastically during the Second World War. Initially in the same pattern that prevailed previously of mobilizing forces for a particular conflict with the intention of demobilizing them afterwards. And indeed, in 1945, there were attempts to demobilize the American military, but they were stopped short in 1947 by the passage of the National Security Act of 1947. National Security Act of 1947. The National Security Act of 1947, anyone know where it did? Prior to 1947, the United States had a Navy and an Army. And both were mobilized when necessary and demobilized when not necessary, and consequently didn't really exist during periods of peacetime. The National Security Act of 1947 instead unified these separate branches under the Department of Defense. It unified the Army and Navy under the Department of Defense, but also expanded it by including the Air Force, which previously had been attached to the Navy, but had demonstrated its effectiveness and its usefulness in war during the Second World War, and therefore became a third and equal branch. And finally, there's the U.S. Marine Corps, whose technical function is to protect American borders, which is also technically attached to the Navy, but in the Department of Defense has likewise become a separate branch of the military. In other words, from 1947 on, the president had a permanent military, a permanently mobilized military, justified by the Cold War. The National Security Act of 1947 did a number of other things. It also created the intelligence agencies of the United States, and in that sense updated the capacities of the U.S. state to give them similar capacities to the British with their MI5 and MI6 and other intelligence agencies around the world. The United States previously did not have a real intelligence agency other than the Bureau of Investigation and the Bureau of Research in the State Department. What's implicit in this is fairly evident. Previously, there was a Navy. The Navy was something that was permanently required, in part in order to create safety of the oceans, to protect emergent fleets, and so on and so forth. But the other department was the Department of War. And the Department of War, as its name suggests, only existed when the country was in a state of war. The Department of Defense was named the Department of Defense, in essence, to suggest that defense is always necessary. In other words, it's something that is permanent. And in that sense, opened up the possibility of expanding presidential power in ways that were previously inaccessible to him. Previously, he had to wait for a declaration of war by Congress and the mobilization of forces and the provision of funds from Congress for that purpose to do anything major in the international environment. Again, that should be qualified. He always did have the Marines at his disposal, and he used the Marines extensively throughout American history. As I think I pointed out previously, the United States has declared war on 5 occasions in its 250 years history, but has used the armed forces in foreign territory on average slightly more than once per year throughout its entire history. Most of those cases were relatively minor interventions in places like Central America, the Caribbean, and elsewhere around the world, but in some cases they were considerably more than that. Suffice it to say that this situation changed rather drastically in 1947. Now the president suddenly had the ability to exercise military power in the absence of a declaration of war, simply using his power as commander-in-chief, which was now permanent, rather than simply being something that he had when authorized by Congress. And that, of course, came to a head in the Vietnam War. The Vietnam War was begun. Well, American involvement in Vietnam began far earlier. It began in the Second World War, when the United States was closely allied with the forces of Ho Chi Minh, who was fighting against Japanese, and the Americans were fighting against Japanese. And my enemy's enemy is my friend, and therefore, of course, Joseph Stalin was the friend of the United States, and so was Ho Chi Minh. But once the Japanese were defeated and Ho Chi Minh insisted that therefore French colonialism would come to an end, the Americans weren't so keen and consequently tried to help the French to regain their territory, their control over Vietnam, which the French badly failed to do, being defeated in 1954 in a valley in Dien Bien Phu by the forces of Ho Chi Minh, whereafter the United States tried to contain the damage by essentially insisting on the division of Vietnam into 2 sides, the northern half controlled by Ho Chi Minh, and the southern half controlled by the remnants of the French colonial authority and governed by a hand-picked leader of the United States who had lived for most of his life in the United States and had little or no legitimacy in Vietnam. The South Vietnamese government was very quickly seen by the Vietnamese as a continuation of French colonialism and as illegitimate, and therefore a kind of insurgency rose up against it within South Vietnam that was being held by the North Vietnamese government of Ho Chi Minh. In that context, the Americans started to send in military advisors to train the South Vietnamese military to defend themselves. But that turned out not to work all that well, in part because the South Vietnamese military was badly corrupt, and most of the funds that were provided them disappeared into private bank accounts and things along those lines. But ultimately, in 1964, the United States became directly involved in the conflict and sent in their own combat troops. They did so as a result of a resolution passed by Congress called the Tonkin Resolution, named after the Gulf of Tonkin, off the coast of Vietnam, where the American military claimed that the North Vietnamese had attacked American ships in international waters on 2 occasions, justifying some kind of retaliation. Subsequent investigations found that it was largely a hoax, that the first attack apparently did occur but it occurred after American naval vessels repeatedly charged toward Vietnamese waters, feigning an attack and trying to get a reaction from the North Vietnamese. And while the reaction might have been in international waters, although that's still somewhat disputed, the Vietnamese say that it was actually in their waters. The fact was that it was quite clearly intended as a provocation. The second incident occurred in international waters and unambiguously, but according to recent or more recent studies, it never really occurred at all. In other words, there was a false radar alarm of incoming torpedoes that turned out not to be torpedoes, but probably were a whale or dolphins or something else that was mistaken by the radar system for an attack. The sailors that were interviewed on the ship never saw any sign of a torpedo or any sign of an attack. Suffice it to say that all of this came out months later, and in response to these provocations, Congress passed the Comparative resolution, which authorized President Johnson to do whatever he thought was necessary to deal with these provocations. And President Johnson took that as a declaration of war and sent in American troops into the longest conflict that the United States was involved in, lasting well over 12 years, and in which the United States was ultimately defeated. And it's this use of American military power that once again resulted in an attempt by Congress to reassert itself and to right the problems created by this expansion of executive power through what became known as the War Powers Resolution or Act of 1973. The War Powers Resolution basically states that the president has to get authorization from Congress for any use of American military personnel in hostilities in foreign territory before troops can be sent. However, it recognizes that this getting authorization from Congress in the context of the Cold War was problematic. In other words, the president has to react to international events, in some cases in a very rapid way. For example, a nuclear attack against the United States, in which the president would have a half an hour to respond to the provocation or to the attack against the United States, and certainly would not have time to get authorization for that from Congress. And therefore, it attached to this idea that the Congress had to authorize all foreign interventions, the requirement that when it was necessary for the president to act instantly without prior authorization, he had to inform the Congress within 48 hours of such a deployment, had to get approval from Congress for that deployment in the form of a declaration of war or something along those lines within 60 days. Without such authorization, those troops would have to be removed from hostilities. And in some cases, when that was logistically difficult, he could apply for a 30-year extension period, or 30-day extension period, to facilitate getting troops out of a combat situation. The basic idea of the War Powers Resolution, as it was understood by most, was to rein in the presidency. Given that it was an attempt to weaken the presidential power, it's quite clear that they could not expect the president to sign off on this legislation. And indeed, President Nixon vetoed it in 1973, and it was passed over the veto of the president by a 2/3 majority in both houses. Interestingly, all presidents that have occupied the White House since that time have nominally complied with the requirements of the War Powers Resolution, although to a certain extent that's debatable, but have at the same time maintained that they consider it to be illegitimate, that they consider it to be a violation of the separation of powers, and that don't feel bound by it. It has never come to the Supreme Court so far, so that is so far untested, at least in the courts. There's a few problems with the War Powers Resolution. One of which is, while it was intended to weaken the power of the president, many have argued that it did exactly the opposite. That prior to the War Powers Resolution, there was never any indication that the president was free to do with the armed forces whatever he wanted for 60 days. But in essence, now he had that window of 60 days. And that proves problematic, because once you've committed forces into hostilities, it's pretty difficult for the Congress to then vote to get them back out without embarrassing the United States and undermining its international authority. This is something that was well understood by the predecessors of President Johnson and Nixon. For example, one of the problems with this division of powers was noted in the administration of Teddy Roosevelt. Teddy Roosevelt came to power after the United States defeated Spain in the Spanish-American War, and he was one of the main quote-unquote heroes in marching up the San Juan Hill and defeating the Spanish forces, which helped him to get elected. But when he assumed the presidency, he decided that since the United States had defeated one of the great powers of Europe, it had become one of the great powers globally, and that it had to demonstrate that to the rest of the world. And the best way to demonstrate its ability to act as a great power and to project power in all corners of the globe was to send the American Navy around the world. And he went to Congress to get money to send the Navy around the world, and folks in Congress looked at them and said, well, either we're world power or we're not, and sending the Navy around the world seems like a stupid waste of money. We either have the capacity to project power or we don't, and rejected it. You want to know what happened as a result of that? Well, Teddy Roosevelt got his generals or his admirals together and asked them, well, on the basis of the resources that we have, could we get the Navy around the world without congressional funding? And they said, no, we couldn't. And they said, well, how far could we get them? Well, we could get them as far as the Philippines. And President Roosevelt said, okay, well, let's send them to the Philippines. Once they're there, Congress will have no choice but to bring them back. In other words, once they're there, Congress's hands are tied. And in that regard, the same thing applies to military commitments. Once the United States is in a military commitment, it becomes very difficult for Congress to undermine that commitment by pulling American troops out. In that sense, their hands are to a large extent tied. The system of checks and balances in this regard, with respect to foreign policy, has become rather problematic. And that has been in part the case as a result of the enormous bureaucracies that have expanded within the executive branch, most important of which is the Department of Defense, which is by far the largest. That expansion of executive power based on the expansion of the executive bureaucracy has only continued since then, and most importantly continued after the attacks of September 11th, with another expansion of the federal government through the creation of the Department of Homeland Security. What becomes evident in this regard is that the constraints on foreign policy that were intended by the framers to constrain the ability of the president to use military force have to a large extent evaporated. And the executive branch has become far, far more powerful. So much so that in the 1960s, at the height of the Cold War, John Schlesinger, the famous political scientist, declared that the United States had succumbed to what he called the imperial presidency, an imperial presidency. One that essentially had no checks in regard to his actions, either militarily or otherwise. And this is something we'll look at in much more detail as we move forward, in particular in terms of the activities not just of the military, but also the intelligence agencies that arguably ran amok during the period of the imperial presidency from the 1950s until the 1970s, when Congress started to try to reassert itself through the War Powers Resolution and through various investigations and the imposition of oversight, in particular the Church Committee and Pike committees, that investigated the activities of the intelligence agencies in the 1950s and 60s, and uncovered activities on the part of the intelligence agencies that they considered to be extremely problematic, and downright illegal. In other words, the involvement on the part of the Central Intelligence Agency in things like assassinations of foreign leaders, of eavesdropping on various officials around the world, including individuals in the United States and so on. We'll take that up in more detail in coming lectures. What I wanted to focus on today was the role that the public plays in American foreign policy and has played historically. But I've noted that I'm almost getting to the end of my time of welcoming this room. The two clocks the clock on here and there are slightly out of sync with each other. I think the one there is correct. So let me just begin by introducing that topic, and we will hopefully get caught up with where we're supposed to be on the syllabus next time around. The United States considered itself one of the first democracies in the international system, and as such, considered legitimate only acts by the government that are endorsed by the general public in the form of elections and in the form of direct participation by the general public. And furthermore, as we'll discover, the general inclination was to think that popular sovereignty would result in different sorts of foreign policies, In other words, would make the United States more passive more peaceful than its European counterparts, whose foreign policies were dominated by military generals and foreign service officers that were largely unaccountable to the general public and consequently looked out for their own interests, which in many cases led to war in unnecessary circumstances. So how effective is the United States in or is the public in the United States in affecting foreign policy? I would argue that there's three ways of looking at this question. And I will only look at one today. The first is to look at public opinion. And its impacts on foreign policy, the extent to which it is a constraint on the policymakers in Washington, or the extent to which it propels policy on the part of decision makers in Washington. The second means of looking at the impact of the public on foreign policy is to look at foreign policy through the lens of ideology, which relates to the beliefs held by individuals about the nature of politics and what is not legitimate. The final means of looking at it is through the lens of political culture. And looking at policy through the lens of political culture is, in essence, the home turf of a school of thought that is now generally recognized as constructivism, which is a kind of a critique of realism. Realism, you might recall, holds that all states act rationally to defend their sovereignty and their position within the international system. And realism in that regard does not provide much scope for the public affecting, or the beliefs of the public affecting foreign policy. Foreign policy is a rational response to threats that are imposed on a state to which it has no choice but to respond. Many critics of realism have argued that rationality is inherently something that is bounded. In other words, something that seems rational to one person will not necessarily seem rational to somebody else because they approach the problem with different kinds of assumptions. We'll look at that in more detail next week. For now, let me just bring up public opinion. The conventional wisdom in American political science about the role of the public in shaping foreign policy, and indeed in shaping policy more generally, is that it does not have any role in shaping public policy, and foreign policy in particular, and furthermore that it should have no role in shaping foreign policy. This was a perspective first argued by Walter Lippmann. That has since then been labeled the elitist. Theory of politics. And it has many more modern adherents, such as Gabriel Arnd and so on and so forth. But the basic observation of Walter Lippmann is that the public should not have any impact on the shaping of foreign policy, in large part because public opinion is inherently, how do you put it, volatile, incoherent, and unstructured. Volatile, incoherent, and unstructured. And given that volatility and incoherence and unstructured nature of public opinion, political leaders would be foolish to look to the public for direction in shaping foreign policy. Instead, he argued that given the ignorance of the average American, it is the role of the elites, those that control government and foreign policy, to determine what is in the national interest of the United States, and then, to use his phrase, manufacture consent for it. Manufacture consent for those policies. Now, Walter Lippmann and that elitist theory has been criticized fairly extensively since it was so blatantly presented by Walter Lippmann. And the more recent incarnations of essentially the same theory argue that this is too simplistic. Essentially, they argue that, yes, what Walter Lippmann states is absolutely true for probably around 75% of the American public, which don't have any awareness or understanding or much knowledge about foreign affairs, and couldn't care less about them. But that other 25% does not fit that description. This is what is often referred to as the attentive public. To be distinguished from those elites, or the elite public. The attentive public, he argued, are those that are relatively well educated, that read international newspapers on a daily basis, and therefore are relatively well informed about international affairs, and that therefore do have a pretty good understanding of foreign policy and foreign policy matters. What distinguishes the mass public that needs to have consent manufactured from the attentive public are levels of education and levels of wealth, suggesting essentially that there is a kind of a ruling elite or ruling class within the United States that dominates especially discussions of foreign policy. The elite public, or the elites that make policy, represent somewhere between 1% and 2% of the population, and basically those are individuals that are involved in government, that are involved in journalism, that are involved in academia, and so on, and that certainly do have detailed and extensive knowledge of international affairs. In this regard, Walter Lippmann put a great deal of emphasis on the role of the media in playing the role of manufacturing consent for the kinds of policies that are necessary to defend American interests. And he's considered to be probably the father of modern journalism in the United States. Now, to what extent is all of this true? Well, there's quite a few statistical pieces of evidence that suggest that he was pretty much right on the money with regard to his characterization. Public opinion polls, for example, and I'll cite a few different ones from different periods. In 1964, the year that the United States sent several hundred thousand soldiers to Vietnam, 25% of the population of the United States had never heard of the Vietnam War. 28% had never heard that China was communist. 50% didn't know who Mao Zedong was. only 65% were able to find England on a map of the world. And only 60% were able to find Brazil on a map of South America. Now, that's kind of interesting. If you blindly point somewhere on a map of South America, you've got a better than 60% chance of hitting Brazil. It demonstrates to a certain extent something that is fairly evident in American culture. Most Americans don't travel outside of the United States. Only about 30% of American citizens have a passport, meaning that they've ever stepped outside of the United States. And most have little or no interest in foreign affairs. Of the 50 top publications in the United States in terms of sales, only 3 deal with political matters. And they are somewhere between 25 and 50 on that list. In other words, they're not in the top 25. And those are Time, US News and World Report, and Newsweek. And for those of you that have ever looked at Time or Newsweek and sought to be educated by them, you probably found them to be rather frustrating. In other words, the average length of their articles is about this long, meaning that they go into very little detail about anything on foreign affairs. And you'd be hard-pressed to get much knowledge out of them. That was the case in 1964. In 1980, similar polls, 1980 was the year of the elections that brought Ronald Reagan to power, and when the United States was in the midst of the Iran hostage crisis. And when 40 personnel in the American embassy had been taken hostage by Iranian students, upset that the United States refused to hand over the Shah, who was receiving cancer treatment in the United States at the time, for a trial for his human rights abuses within Iran. At the time, 75% of the American public were not able to find the Persian Gulf on a map of the world. 50% were not able to find Japan or South America on a map of the world. Only 14% were able to find the United States on a map of the world. And 16% thought that the USSR was part of the Western Alliance. Good indication, once again, of the level of understanding of foreign affairs. In that regard, it is fairly clear that the public opinion cannot be a strong influence in regard to shaping the foreign policy of the United States. And in that regard, many decision makers in Washington consider themselves well justified in ignoring public opinion in the shaping of American foreign policy. I would have liked to have gone on to looking at ideology and political culture and their impacts on foreign policy, but I'll leave that for next week, and I'll leave a little bit of time for any comments or questions or expressions of outrage and disgust and so on and so forth that you might have before I let you go. If there's nothing of that sort, then thank you for your attention, and we'll see you all next week for another exciting episode of American Foreign Policy. And by the way, just for those of you that may have missed it, the readings will all be on in the file section of the course page by later this evening.